Call the next case, please.
Fairway Capital Partners, LLC versus Tamaryn Gause et al.
Good morning.
Good morning, Your Honor. Thank you. My name is Donald Vowell, representing the appellant Fairway Capital Partners, and I would like to reserve 3 minutes.
3 minutes, yes, sir.
So,
Is it Mr. Val?
Vowell, yeah, V-O-W-E-L-L. I'm kind of late to the party.
Yeah, and you're welcome to the party.
Thank you. We're here on summary judgment. The court granted summary judgment. I'd like to talk about 4 things, if time allows. First, the particularity requirement of Rule 7.02. That seems to be on today. And whether requiring strict compliance with that rule is discretionary with the trial court. Now, they say the contract had lapsed. So I'd like to talk about whether there's any evidence that the contract had not lapsed. Third, whether there is any evidence that Felicia Davis, who was the second buyer, if you will, the one who actually ended up buying the property, had notice of the contract. And finally, whether the definition of malice for inducement of a breach of contract is the same as the definition of malice for punitive damages. Now, the particularity requirement. The rule says that a motion has to be in writing, state with particularity the grounds, and set forth the relief or order sought. Now, this is already in the brief, so I submitted some supplemental authorities, which just got here. I did them over the weekend, but they're new yesterday in the court. But supplemental authorities, and I think that with the original authorities and the supplemental authorities, I think it's very clear that whether the trial court requires strict compliance with that rule is indeed discretionary. And in this case, the court exercised its discretion and did not kill the motion. Here's what the court said. Now, the court is in Memphis, and the opposing counsel came from Nashville. And so the judge says, and they had filed this motion to kill the motion to alter or amend. And so the judge says, well, life is different in Nashville. And I'm hard-pressed to set some case aside with some lawyer having to tell their client that it is because of a foot fault. I realize we're in baseball season right now, but this was...
Well, they're playing tennis as well.
Yeah. So, I mean, the case should be handled on...
Maybe a pickleball reference would be more popular.
It could be. They do have foot faults in pickleball, too. But he says, I mean, the case should be handled on the merits. This is discretion. I'm not excited about doing that, folks, tossing the motion because of lack of particularity. And he says, I'm just talking about the way the wind is blowing here. Then a few pages later, he says, so I'm going to deny your motion. That's page 22 of the transcript. So I think that's that. It's an exercise of discretion. He did it. And so,
do we infer from that the trial court believed it had an understanding of what the basis of the motion was?
yes, and probably that there was no surprise to the other side by the time they got there, and there was no prejudice. You know, the motion to alter or amend was not heard right away, but as the judge or chancellor pointed out multiple times, you could, told the other side, you could have set the motion if you were worried about the passage of time. So I just think it's discretionary and there's just nothing there. So moving on to the question of whether there is evidence that the contract had not lapsed. Now, incidentally, this is interesting. This is the only topic raised in the other side's motion for summary judgment. they want to say that you have to have everything in the motion. The memorandum is, not important. This was the only topic that they raised in their motion. So the contract said that it is to be extended automatically if needed to allow seller to clear the title. That's what it said. Extended automatically if needed to allow seller to clear the title. So whether the contract had been extended or whether it had lapsed seems to be a question of fact. Now, I would refer to the blow-up.
Let me ask you a question. How does a person extend that contract? Who does that, and what's the procedure that's to be utilized?
The contract doesn't really say. It just says if needed to allow the seller to clear the title. So you would assume, or I would assume, that the seller would have to communicate that they needed time to clear the title.
Is there any proof in the record about any of this?
There is. It's right here on the blow-up. This is the order where the court said there was no evidence. This is record page 211.
I don't know if you want me to see that or not, but I can't see it.
Oh, sorry. I tried to set it so counsel could see it also, and I hope you'll excuse me. I hope it's big enough. So right here.
Are you referring to 26?
Yes. And there is no evidence in the record of such act being taken, talking about needing additional time to clear the title. Okay, that's what the court said. Now, the next page I want to show, this is the declaration or affidavit of Jack Keller, who was the original seller. He signed it, or his company was the original seller. And I don't know if it's visible to everybody, but what it says, this is his declaration. In early February 2020, prior to the closing, defendant Gause, that's the seller, and she is not participating in the appeal. Defendant Gause informed me that she needed additional time to clear the title to the property, as was provided in our contract, specifically advising that there were issues with her mortgage company, but that she would close on the property once the issues were resolved. So indeed, this is evidence that the seller, as the court suggests, said she needed additional time.
Is that a disputed fact?
That is all I need to show is a fact, but I think this is undisputed.
I mean, was that presented to the court in defense of this summary judgment motion?
It was.
Okay.
It's record page 116, declaration, and it's in the statement of uncontested facts and all that.
Okay.
So. This next blow up, this is record page 24. This is an email. And what went before this email, the Jack, if you will, Jack Keller, he wrote to the seller in July. This is a few months or a month or two before the closing. And he said, I'm making formal demand. This is through counsel, I think it was. I'm making formal demand that you immediately honor the contract. So she writes back. This is her email, August 19th. And I've kind of lost track of my time, but I think this is a week or so before the closing, if I'm not mistaken. And so she says, as I told you from the beginning, I must know the payoff balance to ensure there is no balance for me to pay after the sale. I have requested the payoff several times from the mortgage company, but yet to receive it. I assume that the COVID-19 pandemic has caused the enormous delay, but I am at the mercy of the mortgage company. I hope you understand and consider this in your forcing a lawsuit against me. Please reconsider whether waiting is all that I can do to prevent a later problem. Again, a week before, no mention that the contract had lapsed. She didn't think the contract had lapsed. Obviously, the buyer didn't think it had lapsed. And so, and this is the evidence in the record. And
this is within 1 year? Wasn't
Oh, yes,
the
this-
extension a year?
before the closing was supposed to be, as I told, here's the other one. That letter, yes, that's within a year. The contract was like January, this is August. This email is August, but the other affidavit said that she told him that she needed more time, like before the original closing date. But what makes this more interesting is apparently nobody called her to ask her. If they had called her a week before closing, if I have that time right, that's what she would have told them. So, and that leads me to, well, I guess the next topic. The Regency Title, that's the title company, the agent for the seller. They apparently said the contract had lapsed. Well, again, didn't ask her. And Regency Title confirmed at closing that a title issue had been resolved. That's from the request for admission or responses. So that's a legal conclusion, an incorrect legal conclusion. And so they made that decision at their peril and at the peril of their principal, Miss Davis, Miss Davis. And again, that's the only issue stated in the motion. They raised other issues stated in their memorandum, which given time constraints, I probably won't be able to address. But we've got actual, constructive, and inquiry notice here all over it. And there really is just no question, seemingly, that there is indeed a question of fact of whether this contract lapsed. Thank you.
All right, thank you, Mr. Bowell. We'll hear from you on rebuttal. Counsel, do you care? Do you need to refer to them?
If you don't mind.
If you want one of the others, just let me know.
Thank you so much, I appreciate it.
Good morning.
Good morning, Your Honor. May it please the court. Ross Johnson of the Nashville Bar on behalf of the appellee here, Felicia Davis. I first want to address the Rule 7 issue, and I don't want to belabor it too much, but except to say that I and with all due respect to the Western District and Shelby County, while I am a Nashville attorney, I do think that this was more than a foot fault. And I do think there is something there, despite what opposing counsel stated. I've briefed this pretty thoroughly, I believe, and I've looked at quite a bit of cases on this issue over the past month. And I think what makes I disagree with the kind of broad characterization that it's up to the discretion of the trial court as to whether a motion must be a motion, whether it must comply with Rule 7 and state with particularity. And at the very least, I think it's not discretionary so far as this court's jurisdiction, and the court has said as much that compliance with Rule 4 of the Rules of Appellate Procedure, that and bestowing jurisdiction on this court is mandatory. And in looking at the case law on this issue, and there's a decent amount of it in Tennessee, but there's other cases that I cite that I think are more on point. But at the very least, I think if you look at the cases where this issue has been addressed, there's two issues that really stand out. One being the timing of when this motion was filed. You do see cases, which I admit, that where the court does note that when we're dealing with perhaps early in litigation, perhaps a motion to dismiss, that, and they find no prejudice and that both sides were able to argue the motion, they allow it, they apply the rules leniently, I think is the term that they often use. But the second issue that you'll find in these cases where the court has applied it more leniently is that the motion is not completely devoid of any legal argument or fact or substance whatsoever. Because, again, and you can look at the supplemental authorities that opposing counsel presented. In all those cases, the motion perhaps cites a restatement, perhaps cites another rule of civil procedure, perhaps there's sufficiency of process, or a memorandum of law is attached directly to the motion. That is not what happened here. Here there was, they filed a motion that just copy and paste Rule 59 and attaches the order that they're objecting to. They do not provide any substance or facts as to what they want to alter or amend or why they think it should be altered or amended. And they do not provide a memorandum. They submitted their memorandum 171 days later, actually on the eve of when we were supposed to hear my motion to strike their motion for reconsideration. They finally submitted a memorandum the night before, and I don't believe it's in the record, but we went before the court that day, and he...
Did your client identify the prejudice that it would suffer if the motion were heard?
Well, Your Honor, and this is where I struggle with that term, Your Honor, because the prejudice that my client is suffering is that they're being left in a case and for now...
That's always the prejudice. But
correct, Your Honor. And so where I struggle is, of course, Your Honor, a trial court can continuously delay. A trial court can continuously postpone a hearing and give me an opportunity to file a response. And that's what happened. But I think, again, and I would point your attention to while not controlling, but I think these cases are really important. The Tolano case that I cite, which is the Seventh Circuit Court of Appeals case, and the Shodin case, which is an appellate court from Illinois, where in so many words, the court found that that's not the issue. The issue here is that if we allow this type of behavior to continue, where we allow parties who have lost to file these skeletal, bare-bone motions, these cases can continue indefinitely, and more importantly, the rule has no meaning. And so, again, I think the important issue here is, A, the procedural posture of the case. When this motion was filed, it was an attempt to improperly, I believe, extend this case. I did act in response as promptly as I could, and I got a hearing as promptly as I could, which was again continued. And so, and again, the second point being, which I think is important, and where this distinguishes from other Tennessee courts of appeals cases, for instance, the Grogan case, where the issue was looked at, where the court bends over backwards to try to find a reason for why a motion could comply with the rule. And in that case, they find a citation to the restatement in the body of the motion. And in that case, a memorandum of law was included with the motion. And frankly, Your Honor, if that had happened here, I probably wouldn't be making this argument. That's not what happened here. This motion, it was blatantly obvious to me what they were trying to do. And I, respectfully don't think that should be allowed, and certainly isn't appropriate or allowed for under the rules. Going to the substance, and I think it might be helpful to provide a bit more of a factual, correct some of the, or perhaps more accurately state some of the facts that opposing counsel stated here. They entered in, Keller Investments, who assigned the contract to Fairway, entered into a contract on January 20th, 2020. The contract, in so many words, says you're supposed to close on February 20th, 2020. That didn't happen. There are arguably ways that contract could be extended. One, by giving, if the buyer, that is the plaintiff appellant here, gave notice of the need to extend the contract for 15 days. or if the seller needs additional time to clear title, and it doesn't provide much by way of how that notice is supposed to be provided. I will say that the contract states time is of the essence. I will say that the contract contains a standard contract integration clause. But come February 20th, from my client's perspective, there is no evidence, nothing in the record indicating that any of those mechanisms had been taken. And that, in fact, this is the first time I'm hearing that they're now trying to say that this email here is somehow indicative of the fact that Ms. Gause, again, the original seller, was trying to clear title to the contract. That's not what they put in their complaint. Their complaint says the contract, it's paragraph 24 of the complaint, the complaint says the contract was breached on February 20th. That's 5 months before my client even enters the picture. My client enters into a contract with the same seller on July 20th. It is during that intervening period that Regency title and closing is scheduled for a month later or thereabouts, and it was during that intervening period that the title company, Regency Title, did a title search and discovered this other contract. What was not mentioned, and what was briefed ad nauseum during both the summary judgment proceedings and in our appellate briefs, is when we filed our motion for summary judgment, there was no evidence in the record that this conversation had supposedly happened between Ms. Gause and Jack Keller of the plaintiff, wherein she supposedly indicated to him, I need more time to clear title. So importantly, though, what the record did indicate was that that conversation was never relayed to my client and was never relayed to Regency Title. The record's clear, and you can look at their own language. In the demand letter that came from, and in subsequent emails that came from plaintiff, the demand letter, like the complaint, says we're the only ones who are allowed to extend the closing period. It makes no mention of the supposed conversation that had happened 5 months earlier, where supposedly Ms. Gause had indicated she needed time to clear title, and by virtue of that, I guess the contract had extended automatically for a year. There's no mention of that in the complaint, because again, they said you breached, the complaint and demand letter says you breached the contract by failing to close on February 20th.
Are you saying that's not in the record?
This is in the record, Your Honor. However, this is in their complaint and in their brief, and it's the first, there is no mention, that this argument was that this email was somehow a reason to extend the comment. They're not making the equivalence of this was a communication that extended the contract by a year. The other important issue is this is.
So you're saying that argument was never made to the trial court?
Correct, Your Honor.
Okay. Do we have a transcript?
Or in the briefs, I don't believe.
Do we have a transcript of the summary judgment hearing?
We do, Your Honor.
Okay.
The other, probably more important point, Your Honor, is this is August 19th, 2020. This is 5 months after my client has, or a month after my client has entered into a contract. So, and until today, the argument was no, that there was this secret conversation that happened in February of 2020 between Ms. Gause and the plaintiff that extended the contract to a year, perhaps, I guess, to February of 2021. That was what they argued at the motion for summary judgment proceeding, and until today, that's what I thought their argument was going to be. But again, this was never relayed to my client in July or August when they were closing on the deal. And again, it's 5 months, 6 months after the seller here, the other seller, Ms. Gause, was supposed to have already closed. So my argument I like this argument better because by this point, their contract has clearly expired. Because we're past February 2020 is when they were supposed to close, and before that date, there was supposed to be some type of
But doesn't that document suggest that the seller presumed that the contract was still alive and she needed more time.
It could, Your Honor, and that brings me to another point that I think has been lost, and that is that they've accused my client of tortious interference with a contract. And
The question there is, did your client know?
well, and my argument would be, A, she did not have knowledge of this. B, simply having knowledge of a contract, of its prior existence, I think would not be enough to satisfy the elements of the claim, because it's
Well, that
undisputed.
brings on an interesting question. As I understand, the contract was recorded in the Register of Deeds office.
Correct, and that's how it was
And-
discovered.
and the title agency ascertained it was there, correct?
Correct.
What's the duty of the title agency at that point in time to determine the validity of the contract?
I think it's the inquiry notice standard that I think both sides have, well, I put into my brief, and that it's elaborate, they touched upon it in these supplemental briefings. It's essentially, as I read it, as a duty of reasonable care, a duty of having to take what's presented before you and do a reasonable investigation, which was what was done. And
So what investigation was done?
And that's is where some of the back and forth comes in. The title company, from my client's perspective, all that,
Are the facts disputed about what was done?
to my, I think the facts are not disputed as to what was done. I presume the facts are disputed as to what should have been done, but I'm, again, from my client's perspective, and I believe from...
I'm not sure what you just said.
It is undisputed, Your Honor, that when Regency Title discovered the contract, they contacted plaintiff's counsel and asked for information regarding it, and received received the letter of representation as it's presented in the contract, in the briefings, and asked for information as to what had been done to extend the contract. And at that time, the letter that they got in response was a July demand letter from plaintiffs that stated, "You failed to close on this contract." It makes no mention of this supposed conversation between Ms. Gause and plaintiff. It makes no mention that the contract had automatically extended for a year. Instead, what it says is, "You didn't close on February 20th. We are the only ones who are allowed to extend the contract." And separately, in an email from one of plaintiff's counsel, she states in the email to Regency Title, "This is the only communication we've had with Ms. Gause." So my point being,
So did the appellant tell you the contract was still valid, or to tell Regency Title?
yes, they said that they were still intending to enforce the contract, and
Okay, so at this point in time, the title company is made aware that the appellant believes that the contract's still valid.
correct, yes. They've
So what duty then does Regency Title have at that point in time?
Well, again, I think it's it's at the inquiry notice standard is to take a reasonable investigation and look at what's in the record, and by record I mean what's in the public record. And the only thing that's in the public record is the recorded contract and what they've received from the plaintiffs. But again, I don't represent Regency Title.
So isn't Regency Title your agent?
Yeah, I believe my client did not hire Regency Title. I understand they were handling the closing for my
You're
client.
acting on their information, correct?
Yes, she was acting on their information. The information was that the title issue had been resolved, and that's what my client presented in her affidavit. So,
If you will wrap up, Mr. Johnson.
yeah, well, unless there's any further questions, I wanted to make the point again that simply knowledge of in my opinion, Your Honor, the knowledge of the contract is not enough. I think what we're dealing with here is an intentional tort and an economic one, where you need to demonstrate that my client, Ms. Davis, who didn't know who these people were, was acting with malice and had a specific intention to injure them. That is what the trial court found, and that is what continues to, I think, to be lacking in their argument. So with that, I'll wrap up. Thank you very much.
Thank you, Mr. Johnson. Mr. Bowell, your rebuttal.
Thank you, Your Honor. I'll try to hit on that point. This is record page 75. This is request for admission answered by Ms. Gause, and admit that you or someone you hired performed a title search on the property prior to closing. Admitted, so it's her agent. She hired him. Admit that the title search you obtained revealed the contract. Admitted. So, you know, we've got every kind of notice that known to law. He says there's like a secret conversation, and was never this message here, or maybe the other, was never relayed to his client. Well, maybe they should have called. Maybe someone should have called Ms. Gause and said, hey, what's up with the contract? We see that it can be extended. This is what she would have told them. It's still alive. The contract is alive and well. And then the title company writes to Kurt Runger, the attorney for Keller Investments, and they say, I see Jack, that's Jack Keller, filed a clout on title, but we're wondering what other legal action Jack has taken against Ms. Gause. So the attorney answers, I anticipate that my office will be moving forward with a lawsuit for breach of contract. So there should be no question that they have been told that there's a question of fact, if you will, about whether this contract is in effect. And so there was a question about when they learned things, and they said that it wasn't in the complaint. These things that I've put up on the board, that's our side's response to the motion for summary judgment. That's when you're supposed to do it, is when they file a motion for summary judgment, you file a response to it. And that's when it happened. Now, talking about prejudice, of course, cases always take too long. Passage of time is not the same as prejudice. And I think I've got just enough time to mention a point or two on Rule 7.02. This is in the supplemental authorities. It talks, this is a Tennessee case, when no prejudice resulted from the delay, meaningful opportunity to respond. This is a federal case. Whether any party is prejudiced, it's flexible. However, and non-particularized motions have been allowed when the opposing party knew or had notice of the particular grounds being relied upon. And there's no doubt here, they may have come and the hearing was even postponed to give them time to respond. This is from a case, the federal courts do not apply the particularity requirement as a procedural technicality to deny otherwise meritorious motions. The thing about actual notice, it's what would lead a reasonable person to believe in the existence of the contract and the plaintiff's interest in it. So we have all sorts of facts to the effect that that would lead a reasonable person to believe that there was in the existence of this contract. It did exist. Ms. Gause knew it existed a week before closing. And everybody was on notice of it. And I think, here's one other case. A duty to learn whether his actions will cause the lessee to breach this agreement. That's Wells Fund 1, that's Tennessee case in our supplemental authorities. So I think that pretty much wraps up my comments. Thank you very much for attention.
Thank you, Mr. Vowell and Mr. Johnson, for your arguments. We will take your case under advisement.